The reality is that often, I think in your experience maybe has shown, that simply because you have a case that starts out as an abuse neglect case doesn't mean that at some point the child might find themselves in a delinquency case, or the child might find themselves in an adult criminal court. Or the other way around, exactly. So everybody can listen to this, and it is, what I'm going to talk about are the immigration consequences of juvenile delinquency disposition. So these are for cases that are originally filed and stay in the juvenile court, or if they're district court cases or filed as adult cases but get waived or transferred back into juvenile court. I am not going to cover in great detail the consequences of adult criminal convictions, because the leading book on adult criminal convictions and immigration is 2 volumes that are about this thick. The thing you want to know is that under immigration law, juvenile delinquency dispos are not considered convictions for immigration purposes. So if you have a child who has been arrested and is going to have some kind of proceeding against them, it is, in my opinion, going to be almost 100% of the time advisable that case is dealt with in juvenile court if the child is not a U.S. citizen. And I understand that from the reading that I've done, that the percentage of cases filed in adult court for children who are 16 or 17 years old is like roughly half of the cases are filed in adult court. If you're an attorney who represents those kids who are in adult court and you have a child who's not a U.S. citizen, it's really time to think about whether it's possible to get that case back into juvenile court. Now, maybe there are reasons why the child doesn't want it in juvenile court. Maybe there are reasons why the judge doesn't want it in juvenile court. And at the end of the day, the judge is going to decide where the case is going to land. But I think it's really important that you as the attorney and you as the prosecutor and you as the person advising the child make sure that the child has some understanding of what it means for the child to proceed in adult criminal court. Because things that seem really minor, possession of marijuana in a 16-year-old child, if that's dealt with in juvenile proceedings, it really may not be a big problem for immigration. But if you have a 16 or 17-year-old child with a minor possession of marijuana in adult court, that could be a deportable, serious offense in the immigration world. And so it's really important to recognize that ultimately it may not be your decision. Ultimately, the child may not want to go into juvenile court. But it's really important that the child understand that there can be really serious consequences to adult criminal convictions for immigration. And again, this is another thing for those of you who represent parents that's really important for you to understand as well, is that if you have parents who wind up in adult proceedings, criminal proceedings, the immigration consequences of those can be really severe. They can be really severe for people who are undocumented, people who are refugees, people who are lawful permanent residents, because the reality is that, like we talked about before, just because you're a lawful permanent resident doesn't give you the absolute assurance you will never be removed from the United States. That there are things called grounds of deportability that people can fall into, and if they do, the fact that they have a lawful permanent resident card is not going to prevent the government from trying to put them into removal proceedings and have an immigration judge decide whether the person's going to stay or the person's going to go. So I just want to raise that as an issue, the whole juvenile versus adult court divide. And I'll talk about the juvenile consequences now. But there are quite a few resources that are out there for people who are working with folks who are in the adult criminal system. And they're on the resource list that I gave are a couple of organizations. There's one called the Immigrant Justice Network. There's another one that's specifically for people, public defenders who represent children, that has a lot of information about immigration and juvenile delinquency and adult crimes. So you can always email me and I can give you more of those resources, but I tried to list some of them. But just be aware, adult court, really not good for immigration. Now on the delinquency side, say you have a case, it's in juvenile court, it's staying in juvenile court. Just because it's not a conviction for immigration purposes doesn't mean that we can all act like there's never going to be a problem, because there are some circumstances in which having certain things happen in delinquency court may create immigration issues for the child. And the reality here is that there, like we talked about before, there are those grounds of inadmissibility. So maybe there are health-related grounds, there are alien smuggling grounds, there are false claim to U.S. citizenship, but there are also criminal grounds of inadmissibility. And again, these criminal grounds are not triggered by juvenile delinquency dispositions, so they aren't considered convictions for immigration purposes. But there are also a fair number of things called conduct-based grounds of inadmissibility. This means that they don't require a criminal conviction. They just require that the person have engaged in some conduct, and that may make the person inadmissible. And where the juvenile delinquency part of the case comes in is that the juvenile delinquency disposition may be evidence that the government may look to or turn to make a decision about whether the child's inadmissible or not. So what are the kind of grounds of conduct-based grounds of inadmissibility that most frequently come up that may come up in delinquency cases? And the first one, drug addiction or abuse. The immigration law is incredibly concerned about people who have drug problems, people who deal drugs, but also people who use drugs. And the definition of someone who is a drug addict or a drug abuser is incredibly broad. If you have a child who has had a single experimentation with marijuana, they may not be considered a drug abuser. But if you have a child with a couple uses, if you have something even more serious than that, even without actual evidence of addiction, that child may fall into this ground of inadmissibility. And so the doctor approved by the Immigration Service is the one that makes determinations about these medical grounds of inadmissibility. But certainly if you have a child who is in juvenile court and consistently has sustained petitions for drug possession, drug use, is testing dirty on drug tests, that may be evidence that could be used to establish that the child is a drug addict or drug abuser. Now again, if the child is coming forward filing immigration applications, the child has a burden to show that they're admissible. And so, if I have a child who's a drug addict, I can't file for the child and pretend like there's absolutely no drug problem. But my analysis of the drug issue is, initially in the case, will be partly informed in what's happened in juvenile court. If I know that I have a child who has 7 sustained petitions for drug use, and I know that's going to come up with the Immigration Service, then that'll inform whether I think it's a risk or not that the child, would be advisable to take when filing. So it's certainly, the abuse is like practically use, but not some sort of single experimentation. The one thing that's helpful to know is that the Immigration Service looks to the 3 years prior to the filing of the application as well as the time it's pending. So if you have a child who had a drug problem from ages 11 to 13 and now they're 18, they probably will be okay on this ground of inadmissibility because there is some recognition that through treatment or other means, people may kick the drug abuse, even if the abuse is a couple uses of marijuana. This is one of the things we talked about before. The physical or mental disorder may be a ground of inadmissibility. And again, it's not just that someone has a physical or a mental disorder, but that it may pose or has posed a threat to the safety, property, welfare of the individual or others. Or have past disorders that are likely to recur. The way I think that we've seen this come up most in relation to delinquency cases is you may have kids who have sexually abused other children, and they may have some kind of diagnosed mental disorder related to that and harmful behavior associated with it. The Immigration Service also looks to, they don't treat alcohol as a drug under the first example, but they treat alcoholism as a disorder under this one. So if you have a child who has multiple DUIs or a whole history of adjudications that deal in some way with alcohol, that conceivably the child may fall into this ground of inadmissibility. Now again, if you're working on an SIJS case, these are waivable, so there's not, it's possible to get around that.
So how do they discover these things? As self-reporting, or the juvenile records usually aren't as criminal records?
Right. It's the question is about how do they discover this, and the way they discover it is generally through self-reporting. The child is supposed to go to this immigration-approved doctor, and the doctor is supposed to ask a whole series of questions that may identify some of these grounds of inadmissibility. They don't do drug testing, as far as I know, so they're not drug testing people, but they are taking medical history and are ostensibly asking these kind of questions. So there are places on the medical exam where the doctor can check drug abuser, drug addict. There also are, if you see, there are some questions on the adjustment of status form that may go to some of these issues, but they deal more with some drug use and also drug dealing. But if it's a health-related ground of inadmissibility, it's supposed to be identified by the doctor who is approved by the Immigration Service.
So do they search the public record, or they don't?
The Immigration Service will see if it's a child who's 14 or over, they will do background checks. And so any arrest that would show up on a Nebraska, I don't know, Nebraska Department of Justice background check or an FBI background check will show up or may show up on the Immigration Service's radar. The other thing is that there are questions on the application. Have you ever been arrested, cited, a whole bunch of things. And so generally, if you have a child who's been arrested, in all those cases, the answer is yes, and there's a whole explanation that's given. It is kind of amazing how much the Immigration Service can find out about people. And so that's partly what I try to do with my clients is to say, look, I'm evaluating your case. It's really important for me to know the true answers to these questions because I'm trying to help you decide whether you should apply for immigration benefits or not. And if you don't tell me the truth, and there are some of these things that are come in your history and they come out later with the Immigration Service, you might be in a really bad situation.
So once they report to you, you're ethically bound to put them on the form. You can't just leave them on.
Yes. So that has been known to occur as well. And some of these, again, at least for SIJS, are waivable grounds. So the fact that they exist doesn't mean that we would necessarily not file for the kids, but we would want to evaluate whether we think a waiver would be granted. But again, the waiver standards for these are very generous.
And filing a false one would probably be the death knell for
Yeah,
your application.
it is a problem, although it's interesting because at least for special immigrant juveniles, there's actually a ground of inadmissibility for misrepresentations, including lying on an immigration application, but that ground is completely inapplicable to SIJS kids. But it can be factored into discretion. So it is a big problem, there's no doubt about it. Could you get around it? Maybe, but you don't want to be the child or the attorney in that situation. This right here, reason to believe that the child is a drug trafficker. This is a really big problem. I mentioned it before. It's a non-waivable ground of inadmissibility for special immigrant juvenile status. So if I have a child who has been dealing drugs, we're not filing for them. And this does not require a conviction. So it doesn't matter whether you have an adult criminal conviction. It actually doesn't matter if you have a juvenile delinquency disposition. It doesn't actually matter necessarily whether you've even had charges filed against you. If there is any reason to believe the child has been dealing drugs, then generally speaking, we are not going to be filing applications for them unless it's a kind of relief that allows this to be waived. And the U visa is a kind of relief that allows this to be waived. So if you have a kid who can't apply for SIJS because of this, you can still analyze whether they might qualify for a U visa and get a waiver for this problem. But it's a pretty serious one, and it's one that comes up in a lot of adult cases, it comes up in kids' cases, and there is a specific question on page 62 of the materials on that green card application form. There's a specific question that asks about drug dealing. So again, if you have a child in removal proceedings, you might have creative legal arguments about why they shouldn't be held to have been a willing and knowing participant, but it is a big problem. Prostitution is another one, and again, this is conduct-based, so it doesn't involve any delinquency dispositions, whether they exist or not, but certainly having a hit on a background check that someone was arrested and charged with prostitution would raise flags. On the applications themselves, there are questions about prostitution, and the prostitution ground, again, is not looking back forever. It's looking back 10 years prior to any of these immigration applications. Again, I think there probably are good arguments to be made that people are forced into prostitution. They shouldn't fall into this ground. But certainly this is an area where if you have a child who may trigger this ground, you'd really want someone with immigration experience to analyze the case. It is perhaps not surprising that if you hire a prostitute, you don't fall into this ground of inadmissibility because the procurement is about sort of having a business of doing it, being the person who's sort of setting everything up. But if you hire a prostitute, there's no inadmissibility, but if you are the prostitute, then there is. So that is something to be aware of. And this is also, it's waivable for SIJS as well. False claim to U.S. citizenship is, like I mentioned before, usually a huge problem, and people who make false claims are often barred from, many, many kinds of immigration relief. But there is like I mentioned, it's completely inapplicable to special immigrant juveniles. So if you have a child who entered the country with a birth certificate showing she was born in California, that won't bar her from getting SIJS, and she's not even required to file a waiver. And that's a new change with the new legislation from December. It's important to know that even if the child doesn't qualify for SIJS but qualifies for something else, this kind of goes to Vicky's earlier question, but say you have a child who is an infant, and her aunt brought her in as an infant, and the aunt showed a California birth certificate, but the child was really born in El Salvador. The aunt's doing that on the child's behalf is not going to be held to stick to the child. So that's not going to be a false claim to U.S. citizenship by the infant child, or even by the child who is 10 or 12 years old. If I have some suspicion that a child might have been brought in using a birth certificate like that, I always want to know from the child what they understand to have happened. And typically in those cases, the children don't understand English when they come, they may not, so they actually really have no idea what happened, even if the guardian is telling you, you know, this is how we got the child into the country. But certainly the child's age and their own representations are taken into account on the false claim. But people making it on their behalf won't bar them. Okay, this is one area of immigration benefit called family unity. This is actually the one place where you can have problems from delinquency dispositions if they're treated more in a way that's more similar to adult criminal convictions. The one thing I'll tell you is that it is highly unlikely you will ever run into some child who is applying for or has family unity benefits, and if you do, you can always call me. But really, this is for family members of people who qualified for amnesty in the 80s. So at this point, we're getting so far, away from those dates that you probably are not going to run into any children with this. But certainly, this was an area where delinquency dispositions had some effects. One thing that I mentioned before, I'll mention again, is about the gang-related issues. Again, there's no ground of inadmissibility nor ground of deportability related to gang activity, but certainly it's a discretion. It's something that the Immigration Service may look at in their discretion. And there have been proposals to have something similar to the reason to believe drug trafficking for gang members or alleged gang members, so that if the government has a reason to believe someone's involved in gang-related activity, that person would be inadmissible. That is not the state of the law now, but certainly it's something that I imagine actually would get a lot of attention in the news if that happens, and you'll probably know about it, but it's something to be aware of now. The Immigration Service is very concerned about gang activity, but doesn't yet have a statute or a policy that is barring those people from getting relief. Okay, so the biggest issue, I think, or one of the biggest issues for kids who are undocumented, who aren't permanent residents, with their involvement in the delinquency system is not necessarily that the delinquency dispositions make them deportable or removable, but it is more likely that when kids enter the delinquency system, they end up on the radar of the Immigration Service in a way that they wouldn't have if they had never been arrested, or if they were in maybe an abuse neglect case but not a delinquency case. And it seems to be sort of the general, not rule, but general trend around the country that children in juvenile delinquency proceedings, particularly ones who are held in juvenile hall, may be more likely to be turned over to the Immigration Service than are other kids. I would say that generally my impression is that unless the child has a really serious or violent history, they don't really float to the top of the ICE's priority for removing people. But if ICE is constantly getting calls from people in the delinquency system alerting them to undocumented children, they may take action against the kids. And what that usually involves is the Immigration Service placing a hold on a child who's in juvenile hall or facility, and when the child is going to be released, the Immigration Service will be given warning and they'll make a decision whether to pick up the child or not. Typically, those kids are not held by the Immigration Service. I think that the Immigration Service and ICE has a lot of concerns about their own liability for holding minors, what to do with them. There are no secure facilities for kids in Nebraska. And so usually what you have is a child who's turned back over to a parent or a sponsor. So if you have kids who end up on the immigration radar through delinquency, it doesn't mean that everyone can kind of wash their hands of the case, because the reality is the child will probably be right back where he started in your county, and you're going to need to sort of deal with whether it's services or having on probation, whatever else is going to happen, because it's unlikely that there's going to be an immediate removal of the child from the United States. And I'll go into the removal procedures in a bit and tell you about that.
As a practical matter, how do they find out if these kids are undocumented? They don't have driver's licenses. It's kind of like a don't ask, don't tell system.
If it's don't ask, don't tell, then they may not find out. But it's certainly the case there have been locations where probation officers have inquired of this, either of the parents or the children. The people who gave the information don't understand what it may be used for, the consequences of revealing that information. And then that person may give a ring to Department of Homeland Security to inform them that they're here. And I think it's much more common in adult facilities and adult cases. But it is something I think that does happen from time to time in delinquency cases, which is why I'll kind of go over what the procedures are for you to understand. I think that it's very rare that a child in like an abuse neglect case would end up turned into the Immigration Service, but certainly I think it has happened in Florida quite a while ago. It's not unheard of. But I think this is, the delinquency side is a more likely place where that may happen. Did someone else have a question? Okay. So anyway, if the child gets on the immigration radar, it could be that they may qualify for SIJS, U visa, T, asylum, and the whole analysis won't necessarily change there whether they might qualify. But the reality is that, you know, for kids who don't qualify for any of those benefits, they may be able to apply for something called cancellation of removal. But it requires having been in the U.S. for 10 years continuously, and you need to show extreme and unusual hardship to a U.S. citizen or lawful permanent resident relative. And I think it's something like 1 or 2% of these cases are granted a year by the immigration court. So while it's something that is useful to analyze, and also if you're representing parents, and particularly with children with really serious physical or mental disorders, problems, really, you know, sort of serious issues the kids have that need services here, if the parent winds up in removal proceedings, the parent could also arguably qualify for this, and this could be with a U.S. citizen or lawful permanent resident child. So it's something to be aware of. But again, it has a good moral character requirement. Juvenile delinquency dispositions might factor into the judgment about good moral character. I'm going to go over grounds of deportability just to remind you, and I also remind my clients, that again, if you are a lawful permanent resident, doesn't mean the government may not try to deport you. And if you look on page 109 of the materials, you'll see just that happening. This is a client of mine, and he was a lawful permanent resident. He actually got his benefits through special immigrant juvenile status, and he has incredibly profound mental health problems. And he sort of fell afoul of the law in a pretty serious way for a couple of months when he was off of his meds, and wound up with adult criminal convictions and in removal proceedings. And so you'll see that if you have or look at page 109 in the materials, that it's a copy of something called a notice to appear. It's a document that the government creates and serves on people when they put them in removal proceedings. And this was one that was created for someone who is a permanent resident. You'll also see that if you take a look at the previous pages, pages 107 and 108, that's a sample of a notice to appear for someone who is not here with permission, who's not a permanent resident. So the forms are the same, but the reasons they're trying to remove you may be different. And so the grounds of deportability will apply to people who are lawful permanent residents. The thing that's a little bit different here is that the burden is on the government to show that the person is deportable. And so this is where the government's access to juvenile court records can become very important because the child himself has no obligation to provide the government with evidence that he's deportable. And so the government will need to meet its own burden of establishing that the person is deportable. A lot of kids don't realize this, so they will tell a long, very incriminating story to the Immigration Service that may create problems for them. So if you are representing a lawful permanent resident child or adult, it would certainly be a benefit to them to have some understanding about how the information that they reveal may be used against them. They do have the right to remain silent in the face of DHS questioning. I think that it is advisable they may need to reveal their names, but they are not required to provide this kind of information to the government. But be that as it may, drug addiction or abuse is a ground of deportability, and this is for any time after admission as a permanent resident. And so you may have people who become a permanent resident, and 10 years later they don't naturalize and become a citizen. 10 years later, they have a serious drug problem, and if they get on the radar of the Immigration Service, that may actually put them in a category of people who are deportable. False claim to U.S. citizenship is, again, a deportability ground. Some people don't realize this, or some people make bad choices when they apply for jobs or fill out student loan forms or apply for mortgages where there's a question about their immigration status. Now, again, false claim to U.S. citizenship is not me telling my friend I'm a U.S. citizen when I'm not. It's about making a false claim to get a benefit under federal or state law and making the claim to a person who has a legitimate reason to be asking. But you would be surprised how many people have legitimate reasons to ask, including, under some interpretations, employers. So if people are misrepresenting, even if they are perfectly eligible to work, but they check the box that says I'm a citizen rather than I'm a permanent resident, that can be a real problem. And the government is pretty good at getting employment records. And I think that actually in some cases where parents have been picked up in raids on meatpacking plants, other factories, that the government will get access to their employment records and will see all the representations that they've made to get the jobs that they have. And I think those are some places where you start to see prosecutions for identity theft or people being put into removal proceedings. And then one more ground of deportability that comes up, it's not a ground of inadmissibility, but it's a violation of a protective order against violence or stalking or similar behavior. So again, this is something to be aware of. You may have a child or an adult who is a lawful permanent resident, but if they fall into this ground of inadmissibility, it may be that the government will try to put them into removal proceedings. There's also cancellation of removal that's available to people who are lawful permanent residents. So the fact that you fall into a ground of deportability doesn't mean that you're on the next bus back to Canada. It just may mean that you're going to have a really hard time fixing your situation, but you might qualify for cancellation of removal. And the thing about this kind of cancellation is that the requirements are a bit less stringent than they are for cancellation for people who are undocumented. So the immigration law recognizes that lawful permanent residents make big mistakes, but that they may be able to have a second chance, and only one chance. You can't get cancellation removal 10 times. You have one chance to get this from an immigration judge. And there are pretty basic requirements about how long you need to have been here, no convictions for aggravated felonies, and then there is a discretionary component. So the nature of the violation that made you deportable may, factor into that. But again, the delinquency dispos can factor into the discretionary part of this case. So just because it's not a conviction, the delinquency dispositions, doesn't mean that it's completely irrelevant to a claim for cancellation. People may have problems when they try to naturalize. So we talked about naturalizing after 5 years. Once you're 18, you're a permanent resident, you want to become a citizen. Someone with a lot of immigration experience should really look at your case before you apply to become a citizen, particularly if you have any criminal history, whether it's delinquency or adult. And the reason why is because when a person applies to naturalize, the Immigration Service will take their whole file, they're going to look at their whole case again, and they're going to look at the very detailed naturalization application that a person submits. So it's not something to be taken lightly, because if a person who's deportable files for naturalization, not only won't they get a U.S. passport, but they may actually get an invitation to go to immigration court proceedings, because the Immigration Service is going to screen whether these people are deportable or not. And so sometimes what may happen is, if you have juvenile delinquency arrests or hits that come up, when the Immigration Service looks at that case, we'll start questioning whether the child became deportable as a result of any of these dispositions. Not because they're convictions, again, but because they may be conduct-based grounds of deportability. And then there's also good moral character requirement for naturalization. You can have some problems, again, with some conduct. The thing to remember is that typically the period that they're looking at for good moral character is the 5 years prior to filing the application. So if you have a child who is necessarily deportable, but who has a bunch of problematic behavior that you need to get around, it is possible some of these things may improve with time, and that if you have problems that happened years ago, and particularly more than 5 years ago when you're filing for naturalization, that may help the case. It is very unusual that there would be any immigration consequences for U.S. citizens for juvenile delinquency dispositions. The only one that we're really aware of doesn't put the person's own status into jeopardy, doesn't take away citizenship from anyone. But there are certain things that a child may do that may bar their ability to petition for other family members. And so there was a piece of legislation in 2006 that basically prohibits and certainly limits people who are U.S. citizens or permanent residents from filing family-based petitions when they have certain kinds of sexual offenses in their history. So that's something to be aware of. It's not something that leads to deportability, but it is something that is a limit on a person's ability to immigrate other people. Then this is the last slide we'll do, and then we'll go over some hypos on the delinquency side. But basically, the issue here is just like we talked about, that the government, DHS's role in these kind of cases is not to try, particularly ICE's role as an enforcement agency, is not to try to help you figure out what kind of immigration benefit the child may be eligible for, or even necessarily to help you figure out what the child's immigration status is. The ICE's role is an enforcement role, and so if there are issues about what is a child's immigration status, how do we figure out what to do with this case, calling ICE for help is not going to get you very far if what you're trying to do is assess a child's case. And so there are other mechanisms that are much more effective for doing that. Some involve doing Freedom of Information Act requests to the government for information about the child if you think they might have a green card and they don't have a copy. The other thing is that in pages 102, 103 of the materials is something called a G-845. It's a document verification request. And it is possible for, not for me or some other private individual, but for a state agency to be able to submit documents to the Immigration Service for verification of a child's status. I don't know how frequently this is done, but certainly if you have a green card for a child and there's a concern that it may not be legitimate, you could try and do a Freedom of Information Act request, but sometimes responses take years. It's also possible to do a document verification request. It's not clear to me. I don't believe that the government, certainly on FOIAs, is in the business of taking enforcement, sort of enforcement steps against a person if they don't appear to have permanent residency, but I don't know that it's something you can really count on. There is something, if you look on page 103, there's something called Poocall, which is sort of a acronym for permanently residing under color of law. Has anyone heard of that before or dealt with that? Any caseworkers dealt with that? It's not a Proocall, if you ever hear it tossed around, it's not an immigration benefit. It's not like permanent residency or temporary protected status, but it is a designation that the government, federal government, may give to people, to children, that it is affirmatively stating they are not planning on taking enforcement actions against the child. And in the past, at least, that has qualified kids for some federal public benefits. And so I think it's not something that people, I think, are actively really working with that much anymore, although I'm not entirely sure about that, but it is something to be aware of, that if you hear Poocall or if some child, well, see when a child would say, but a child says that, or someone tells you my child is Poocall, what you need to remember is that's not an immigration status. It doesn't give them residency here. It may mean you want to look into it more, have someone evaluate the case, but it's not an independent or freestanding kind of immigration benefit. So what we will do now is, it won't be a break, but in your materials are a set of hypos that are about juvenile delinquency issues. And you'll read these and you'll hope that you never run across any of these situations. But anyway, it's the blue paper. You can talk to the people you talked to before, and we'll just take 10 minutes, and then we'll talk about the answers for 10 minutes. And then in the last half hour, I'm going to go over some basics about removal procedures, and then some local resources and some information on recent legislation. So 10 minutes, blue paper, and you can use the PowerPoint obviously as a reference.